The notice arrived without warning. It stated that a portion of his property had been designated a regulated environmental buffer zone effective immediately, and that unauthorized land modification would result in fines and corrective action. The consequence was simple and absolute: restricted use of land he had worked for over a decade. He read the notice once, folded it neatly, and placed it on the kitchen counter beside his keys. There was no mention of how much land was affected, no citation of survey boundaries, only a reference to a recent HOA-approved clearing operation conducted on an adjacent parcel, work he had not participated in and had not contested. The implication was subtle but firm. Environmental proximity justified oversight. 2 days later, the first marker appeared. It was a fiberglass stake with a laminated warning placard pushed into the soil near the tree line at the eastern edge of his farm. The marker bore the HOA's emblem and the phrase "Buffer Zone, Restricted Area." He did not remove it. He walked the fence line that morning as he always did, stopping only long enough to photograph the marker from 3 angles. He recorded the time. He noted the GPS coordinates from his phone. Then he continued checking irrigation lines, stepping carefully so his boots did not cross the flagged boundary. By the end of the week, there were 4 more. Each one appeared incrementally farther from the original clearing site, forming a loose arc that curved inward toward his grazing field. None were accompanied by additional notices. None were explained. They simply appeared. He responded by doing exactly what the HOA requested. He ceased activity in the marked area. He instructed his contractor to reroute equipment. He adjusted grazing schedules. He sent a brief email to the HOA office acknowledging receipt of the buffer designation and confirming compliance pending clarification of scope. The response came from the HOA's Environmental Compliance Director. Her email was formal, confident, and brief. It thanked him for his cooperation and stated that buffer zones were subject to periodic reassessment based on environmental impact studies. No studies were attached. The following Monday, a laminated map was circulated to residents. The map showed the original clearing site shaded in yellow. Around it was a green perimeter labeled Buffer Area, Provisional. That perimeter extended onto his land, covering a narrow strip along the tree line. He downloaded the PDF. He saved the email. He printed both and placed them in a labeled folder. 3 days later, the markers moved. Not removed, repositioned. The original stakes remained, but new ones appeared beyond them, extending the boundary by another 10 yards. The arc tightened. The shape became deliberate. He noticed that the placement followed natural contours rather than surveyed lines. That night, he compared the new marker positions against his property survey from 10 years earlier. The buffer now crossed a documented boundary pin. He made no comment. He sent another short email acknowledging the updated map and confirming continued compliance. He requested confirmation that the markers had been placed by authorized personnel. The reply came the next day, again from the director, confirming that all placements were HOA approved. The phrase mattered. He highlighted it. By the end of the second week, residents began receiving a second map. This version included a dashed outline labeled Potential Future Regulation Area. The dashed line fully enclosed the green buffer and extended farther inward, covering nearly 3 acres of his land. The map was framed as informational only. No enforcement language, no fines, just planning. He saved this version too. On his own land, nothing changed. He avoided the buffer. He adjusted fencing. He complied so completely that no violation could be alleged. The HOA, meanwhile, began referencing the buffer in meeting minutes. He obtained those minutes through the resident portal. One line stood out. Buffer zone stabilization appears effective. Expansion under review. He added the minutes to the folder. The escalation had occurred without confrontation.
The HOA had acted first, expanded second, and documented everything itself, and it was only the beginning. End of Part 1. Rehook. The markers were no longer warnings, they were boundaries, and the HOA was about to start treating them as permanent.
The escalation arrived quietly, embedded in routine procedure. A new notice was uploaded to the resident portal under the heading Environmental Compliance Update. It announced that the provisional buffer zone had been entered into the HOA's internal planning system for coordination purposes. The notice emphasized that this did not constitute a transfer of ownership or permanent restriction, only a temporary administrative measure to ensure consistency across departments. The consequence followed in the next paragraph. Any activity within the buffered area would now require pre-clearance from the HOA prior to execution. No vote was mentioned, no hearing, no expiration date. He read the notice and did nothing else. That afternoon, 2 additional stakes appeared on his property, this time capped with reflective tape. The placement was precise, aligned with the dashed line from the second map rather than the original green perimeter. The stakes did not replace the earlier ones, they superseded them. He documented the time they appeared by reviewing the timestamp on a motion-activated camera positioned along the access road. The video showed an HOA utility vehicle stopping briefly. 2 figures exited, placed the stakes, and left. No attempt was made to contact him. He logged the footage. He cross-referenced it with the notice time. Then he complied. He halted routine soil testing in the area, even though the tests were scheduled months earlier. He notified his supplier of the delay. He adjusted planting plans. He sent a short email to the HOA confirming that all activity within the newly marked area had been paused pending pre-clearance. The response came within an hour. The Environmental Compliance Director thanked him for his cooperation and stated that the HOA appreciated residents who understood the importance of proactive stewardship. She attached a revised map. This version was different. The buffer was no longer labeled provisional. It was labeled Regulated Buffer Active. The dashed outline was gone. The solid green area now matched the furthest stakes on his land. He printed the attachment and placed it behind the others. The next escalation followed through paperwork rather than presence. A planning memo circulated to committee members outlining future land use considerations related to buffer-adjacent properties. His parcel was referenced by lot number. The memo suggested that continued stabilization of the buffer could support long-term environmental objectives and reduce risk exposure for the association. There was no mention of consent. He accessed the memo through the same portal as before. He noticed that the map included in the memo used the HOA's official boundary legend, the same legend reserved for common areas and easements. He saved that version separately. On the ground, enforcement remained passive. No fines, no citations, only restrictions that expanded by implication. A week later, a maintenance contractor contracted by the HOA entered the buffered area from the adjacent parcel. They placed additional signage along the internal edge of the buffer, signage facing inward toward his fields. The signs read, "No entry, regulated area." He observed from a distance. He did not intervene. That evening, he sent another email to the HOA acknowledging the signage and confirming that his own staff had been instructed to avoid the area entirely. He asked whether the HOA required access logs for compliance verification. The reply was immediate and affirmative. The director stated that access records were helpful and that the HOA maintained its own internal logs for buffer oversight. The phrase mattered. He created a simple spreadsheet documenting dates, times, and reasons for non-entry. He shared a copy with the HOA as requested. The HOA responded with thanks. From that point forward, the buffer began appearing in unrelated contexts. A budget worksheet included a line item for buffer monitoring. A landscaping proposal referenced existing regulated zones. A draft agenda for a board workshop listed buffer alignment as a discussion item. Each document used the same shaded map. Each document treated the buffer as established fact. He collected them all. At no point did he argue jurisdiction. At no point did he cite surveys. He allowed the process to continue exactly as designed. The HOA, emboldened by the absence of resistance, formalized the buffer's role in planning documents. The director referenced it during a recorded meeting, stating that the association had already implemented effective controls and that expansion had occurred without incident. The recording was archived automatically. He downloaded it. The trap was tightening, not through force, but through repetition. The buffer was now policy, and policy, once written, demanded enforcement. The escalation came with a clipboard. An inspection notice was posted to the resident portal at 7:12 a.m., marked Routine Compliance Verification. It referenced the regulated buffer by its internal designation number and stated that an on-site review would occur within 72 hours to confirm continued adherence. The consequence was procedural but serious. Any discrepancy would trigger corrective measures and assessed costs. He acknowledged the notice within the hour. No objection, no clarification request. On the morning of the inspection, he altered nothing. The buffer remained untouched. Fencing stood where it had been adjusted weeks earlier. The warning markers were intact. The inward-facing signs remained undisturbed. His equipment stayed well outside the marked boundary. 2 HOA representatives arrived precisely on schedule. They did not approach the house. They walked directly to the buffer edge, carrying tablets and measuring wheels. They photographed markers, noted distances, and compared positions against the latest internal map. Their conversation was muted and procedural. He observed from the porch. He did not speak to them. The inspection took less than 40 minutes. When it concluded, one of the inspectors affixed a small adhesive tag to the nearest stake, an internal marker indicating verification. That afternoon, the report appeared online. It stated that the regulated buffer was clearly delineated, appropriately respected, and effectively integrated into surrounding land use. It noted that no violations had been observed and that compliance was exemplary. The final line was new. It recommended that the buffer be maintained as currently established to ensure continuity. He downloaded the report. He noted the timestamp. He placed it in the folder. The next escalation followed immediately as though triggered by success. A formal letter arrived by certified mail. It informed him that due to the buffer's effective implementation and absence of conflict, the HOA would be updating its master planning documents to reflect existing conditions. The letter framed this as an administrative alignment rather than a regulatory change. The letter included an attachment. It was a revised planning map. Unlike previous versions, this one removed all provisional language. The buffer was now labeled Established Regulated Area. The legend categorized it alongside common interest controls. The boundary line was thicker. He compared it against earlier versions and marked the progression with dates. He signed the delivery receipt and returned inside. The director followed up with an email that afternoon. Her tone was confident, almost congratulatory. She thanked him for his cooperation and noted that his property had become a model for effective buffer integration. She added that the HOA's council had reviewed the documentation and found the process consistent with internal standards. There was no mention of external authority, no citation of property law, only internal validation. For the first time, the situation felt final. Neighbors began referring to the area as the buffer without qualification. Contractors avoided it automatically. Even his own staff spoke of it as restricted. He said nothing. He continued to comply. That compliance, however, now carried weight against him. A week later, the HOA issued a notice regarding access coordination. It stated that to prevent accidental encroachment, the association would begin maintaining official access logs for the buffer area.
The notice included a request for confirmation that he had no objections. He replied with a single sentence confirming that he had none. The HOA began logging. Vehicles entered the buffer from the adjacent parcel for monitoring. Contractors performed minor stabilization work. Each entry was recorded under the HOA's authority. The logs were shared with him as a courtesy. He saved them. The next escalation was subtle but decisive. During a recorded board session, the director presented the buffer as a settled matter. She referenced inspection results, compliance history, and planning alignment. She stated that the HOA had successfully exercised oversight without dispute, and that the regulated area should now be treated as a permanent for administrative purposes. No vote was taken. None was needed. The statement was accepted without challenge. Listening to the recording later, it felt as though the outcome had already been decided. The buffer had existed long enough, been referenced often enough, and complied with completely enough that it now appeared legitimate. If challenged, it would look unreasonable. If reversed, it would look disruptive. This was the moment where most people would object. He did not. Instead, he organized his records. He arranged the maps in chronological order. He indexed the notices. He synchronized timestamps between emails, portal uploads, inspection reports, and access logs. He highlighted only one thing. Every document that asserted authority did so after the markers had moved. The escalation had not ended the process. It had completed the first trap. End of Part 3. Rehook. With inspections passed and records aligned, the HOA believed the land was already theirs, and that belief was about to be tested.
The escalation arrived as a form letter, stripped of courtesy. It was titled Notice of Administrative Boundary Alignment. The language was precise and impersonal. It stated that based on documented compliance history and planning integration, the HOA was formally recognizing the regulated buffer as part of its controlled environmental framework. The consequence followed immediately. Any future use of the area would require written authorization. There was still no mention of compensation, easement, or consent. The letter was signed by the Environmental Compliance Director. He acknowledged receipt the same day. He did not dispute the premise. He did not request clarification. He simply confirmed that he would continue observing all posted restrictions. The HOA treated this as acceptance. Within days, the buffer began appearing in external-facing materials. A community update newsletter referenced existing HOA-controlled buffer zones and included a photograph taken from the adjacent parcel. The image showed the warning stakes on his land, clearly visible. The caption described the area as successfully stabilized. He saved the newsletter. He noted that the photograph angle concealed the original property boundary marker. The next escalation followed through action rather than paper. An HOA contractor installed a small informational sign near the access road, facing outward toward the main thoroughfare. The sign bore the HOA logo and read, Environmental Buffer Area, HOA Oversight. This was the first marker visible to the public. He photographed it. He recorded the installation time using the same camera footage method as before. He did not remove it. Instead, he updated his internal log to reflect public representation of control. The director sent another email later that week. She referenced the sign and explained that it was intended to clarify jurisdiction and reduce confusion among residents and service providers. She expressed appreciation for his continued cooperation and stated that the HOA's legal counsel had advised consistent messaging. This was the first time legal counsel was mentioned explicitly. The effect was immediate. A regional planning consultant working with the HOA on unrelated matters emailed him requesting confirmation that the buffer area was subject to HOA oversight for the purposes of an environmental assessment. The consultant attached the same map that now appeared in HOA documents. He replied that the HOA had designated the area as regulated and that he had complied with all restrictions. He copied the HOA on the response. The HOA replied with confirmation. That exchange mattered. The next escalation was procedural but irreversible. The HOA scheduled a mediation session. The stated purpose was to formalize understanding and ensure long-term clarity regarding buffer management. Attendance was described as voluntary but strongly encouraged. He agreed to attend. The session was held in a neutral conference room. The director attended with 2 board members and a representative from the HOA's management firm. No attorneys were present. The director spoke confidently. She outlined the buffer's history as though it had always existed. She referenced inspections, compliance, and planning integration. She emphasized the absence of objections as evidence of mutual understanding. He listened. When asked if he had concerns, he stated only that he had complied with all HOA directives and had maintained records accordingly. The mediation concluded with a summary memo drafted by the HOA. The memo stated that the HOA's administrative control over the buffer was well documented and that no disputes had been raised. It recommended that the matter be considered settled pending final legal formalization. He requested a copy. He received it the next day. The final escalation of this phase arrived with a certified envelope. The HOA had filed a petition in local court seeking a declaratory judgment affirming its authority over the regulated buffer area. The filing cited its own records, notices, maps, inspections, compliance logs, and planning documents. The director's name appeared repeatedly. Her affidavit stated that the HOA had exercised oversight openly, continuously, and without opposition. He read the filing carefully. It was comprehensive. It was confident. It assumed that documentation equaled authority. He did not respond immediately. Instead, he prepared. He assembled a timeline showing when each marker was placed relative to each notice. He aligned each map version with its publication date. He highlighted every instance where the buffer expanded before any formal authorization. He included the HOA's own acknowledgments. The escalation had reached court. The second trap was now set. End of Part 4. Rehook. By asking the court to confirm what it assumed was already true, the HOA unknowingly submitted the evidence that would undo it. The hearing date arrived without spectacle. It was listed as a routine civil matter. No jury, no gallery, no urgency implied by the docket. The HOA's petition for declaratory judgment was positioned as a request for clarity, not confrontation. On paper, it looked orderly, confident, settled. That appearance was deliberate. The HOA arrived prepared. The environmental compliance director sat at counsel's table with a neatly labeled binder. Tabs protruded in uniform increments. Maps were printed in color. Inspection reports were highlighted. Access logs were cross-referenced. Everything about the presentation suggested continuity and control. The argument was simple. The HOA asserted that it had identified an environmentally sensitive area following nearby clearing activity. It had installed markers. It had issued notices. The homeowner had complied without objection. Over time, the buffer had been integrated into planning documents, monitored through inspections, and treated as regulated without resistance. The director's affidavit emphasized one phrase repeatedly: uninterrupted administrative oversight. The implication was clear. If oversight had been continuous and unchallenged, then authority must have existed. The HOA's counsel spoke first. He walked the court through the timeline, but not chronologically. He grouped actions by category: notices, maps, inspections, planning references.
Each group reinforced the same narrative. The buffer existed, it was respected, it functioned. At one point, council stated that the HOA's actions had been transparent and cooperative, noting that the homeowner had acknowledged every notice and adjusted his operations accordingly. That acknowledgement, counsel argued, demonstrated acquiescence. For a moment, the case appeared settled.
The court reviewed the exhibits quietly. The judge asked clarifying questions about inspection frequency and administrative procedures. The director answered smoothly, citing records and internal protocols. Then the homeowners' counsel stood. He did not challenge the facts. He did not dispute compliance. He did not argue motive. He asked permission to submit a consolidated timeline. The court accepted it. What followed was not a counter-argument, but a rearrangement. The timeline displayed the HOA's own documents, nothing external, nothing interpretive. Each entry listed the date, the document title, and the action taken. Markers placed, maps revised, notices issued, inspections conducted. The only addition was alignment. Each HOA action was aligned against one static reference, the property boundary survey on file before the buffer existed. The survey did not move. The documents did. The first marker placement appeared on the timeline before any notice authorizing it. The second expansion occurred before the revised map that depicted it. The active designation appeared after the inspection that praised its effectiveness. The planning memo referenced an area that had not yet been formally described. The pattern was unmistakable. Authority followed action, not the other way around. The judge paused. He asked the HOA's counsel to confirm the dates. Counsel reviewed the exhibits and agreed that the dates were accurate. The director leaned forward. She attempted to explain that environmental responsiveness required flexibility, that markers were provisional, that planning documents reflected evolving conditions. The judge asked a single question. Where is the instrument granting the association authority over land beyond its recorded boundary? There was no immediate answer. The HOA's counsel referenced internal bylaws regarding environmental oversight. The judge reviewed them. The bylaws authorized recommendations. They authorized coordination. They did not authorize unilateral land control. The director attempted a different approach. She emphasized compliance history, inspections passed, no objections raised, no interference recorded. The judge acknowledged that compliance was clear. Then he stated something quietly that changed the room. Compliance does not create jurisdiction. The atmosphere shifted. The judge returned to the timeline. He noted that the HOA had represented the buffer as established before it had any documented authority to do so, that it had logged access, installed signage, and referenced the area in planning materials as though control already existed. Each action taken alone appeared minor. Taken together, they described assumption. The court requested the HOA's access logs. They were submitted. The judge compared them against the homeowner's property boundaries. Each entry showed HOA-directed activity on land not owned or encumbered by the association. The director's affidavit, intended to demonstrate continuity, now demonstrated duration. Duration of overreach. The hearing recessed briefly. When it resumed, the judge addressed the core issue. The HOA had asked the court to confirm authority based on its own records. Those records, however, showed that the HOA had exercised control first and sought validation later. That inversion mattered. The court ruled that the HOA had no authority to regulate the buffer area as defined, that its actions constituted unauthorized administrative control, that all references to the buffer in planning documents, maps, and records must be withdrawn. Further, the court ordered that the HOA was barred from asserting future claims over the area based on the same theory.
There was no admonishment, no commentary on intent, only correction. The director did not speak, the binder remained closed, the homeowner did not react. He had not needed to. The system had resolved the matter using the HOA's own work. End of Part 5. Rehook. The ruling was clear, but its consequences would quietly dismantle everything the HOA had built around the buffer.
The order was entered without ceremony. It appeared in the docket as a standard ruling, formatted no differently than dozens of others issued that week. There was no language of rebuke, no narrative framing, no allocation of blame. The court simply stated that the HOA's asserted authority over the designated buffer area was unsupported by law and terminated in full. The effect was immediate, though understated. Within days, the HOA issued an internal directive instructing staff to cease all monitoring, logging, and maintenance activity within the former buffer. Contractors were notified. Access schedules were canceled. A quiet addendum was added to the management system, marking the area as removed from association oversight. No announcement accompanied the change. The signs came down first. They were removed early in the morning, unaccompanied by explanation. The fiberglass stakes followed later that week, pulled from the soil and stacked in the back of an HOA utility vehicle. The reflective tape was still attached. He documented the removal. He noted the time. He updated his log to reflect the final action. The maps changed next. The HOA's resident portal replaced the shaded planning documents with revised versions that omitted the buffer entirely. Where the green area had once appeared, there was now blank space. No notation marked the revision. No archive of prior versions was made visible. He retained his copies. In the following board meeting, the buffer was not mentioned. An unrelated agenda item referenced alignment of environmental documentation, but no specifics were discussed. The Environmental Compliance Director did not present. Her role was later reassigned. The change was framed internally as a restructuring decision. No public explanation was offered. The HOA's counsel advised that the matter was resolved and required no further action. From the outside, it looked as though nothing had happened, but the effect extended beyond one parcel. The court's order barred the HOA from asserting similar claims based on proximity or administrative precedent. That limitation applied to all properties within the association. Planning committees revised their procedures. Environmental language and bylaws was narrowed. New internal controls required external verification before markers could be placed beyond recorded boundaries. The system adjusted. Quietly. On his land, normal use resumed. He instructed his staff to re-enter the former buffer area gradually, documenting soil conditions and restoring routine operations. No notices arrived, no inspections were scheduled, no emails followed. The HOA did not request access. Weeks passed. Neighbors stopped referring to the area as restricted. Contractors treated it like any other field. The language shifted back without instruction. He did not address it. He did not request acknowledgement. He did not seek compensation. The only communication he sent after the ruling was a brief email confirming that all HOA equipment had been removed and that his own records reflected full compliance with the court's order. The HOA replied with a confirmation. The folder was closed. In the months that followed, the association's approach to enforcement changed subtly. Notices became more precise. Maps included clearer disclaimers. Provisional measures were labeled as such, with expiration dates. The director's absence was noted but not discussed. No one spoke of the buffer again. There was no confrontation at the end, no conversation, no vindication seen. The land returned to its prior status not because someone demanded it, but because the system, when presented with its own record, corrected itself. The trap had not relied on deception, it had relied on patience. Every step the HOA took had been voluntary. Every escalation had been self-directed. Each document had been created in confidence, submitted with certainty, and accepted without challenge, until the moment they were aligned. The homeowner had not needed to argue authority. He had allowed the HOA to define it, and in doing so, to exceed it. The result was not punishment, it was removal of markers, of claims, of assumed power. When the season changed, the field looked no different than it had before the first stake appeared. Grass grew back where the signs had stood. The fence line remained intact. The pin markers were still where they had always been. The survey had never moved. Neither had he.